Welcome to The Point of View. This is your favorite current affairs show here on Channel 1 Television. We're live tonight with a very big topic. It's huge. It involves a number of organizations, but it's also a matter of public interest. So it's really the Azumah Resources gold mine in the Upper West region. The engineers and planners, or E&Ps, attempt to raise capital to acquire it. The pushback from Azumah and its other shareholders, and the intrigue around an activist trying to throw more light on a very controversial issue. So it's all live tonight. My guest is Bryce Simmons, and we're going to delve into the issue for the next 55 minutes. We're happy for you to send your comments. Send them to us on the number on the screen. We'll be right back. So tonight, my guest is Bryce Simmons. He is Vice President of IMANI. He is also president of EBID, but he's an activist, and he's been on this particular matter for the past, how long?
Few weeks.
Few weeks. You know, so let me give three contexts for this program so viewers can get where I'm coming from. So there clearly is an issue between E&P, which is a private company, and Azumah Resources Ghana and their owners, which include GIC based in UAE, Kangol PTE, Azumah Resources PTE based in Australia. All right. So it's a private issue, but it's of public interest because once it's a mining concession, the government of Ghana holds all minerals in trust for the people of Ghana. So it is our resource. So even though it's two companies fighting, it's still a matter of public interest. That's point number one. Point number two, we were hoping to have a debate. So we had asked E&P to nominate a rep to be on the show, but they declined to be on the program. But they did send us information based on some of the things they already posted in the public domain and additional information that they felt we could use in the program, at least I could use, in plain devil's advocate. So they have sent a bunch of things, which I will make reference to. Number three, slight point, my guest is the subject of a suit by the CEO of E&P, but for a different matter. So this particular matter, there is no suit, but I'm sure there's the relation there. So those are the three caveats I give. I don't know if you have your own caveat for the program, but those are the sort of context. It's very important for people to know it's a public interest issue because it's obviously minerals held in trust by the government for us. And of course, your court case, we try not to go into it because it may prejudice the matter, right? And of course...
To the extent there's a connection we can talk about.
And of course, number four, there's also a matter of arbitration between E&P and 6 respondents, including Azumah Ghana and the others. So let me just do a quick overview of what I know, and then I'll sort of quiz Bright on some of the things that he has put out. So engineers and planners is at arbitration against 6 institutions. The first respondent is IGIC, which owns Upwest Resources Company Limited. Then there's Kangol PTE, which is a part owner of Azumah Ghana. Then there's, of course, Azumah Australia, which is also part owner of Azumah Resources Ghana. And then there's also Phoenix Resources, which belongs to Azumah. Now, what do we know about this matter? So there's a mining concession in the Upper West region from 1992 there or thereabouts. An Australian came in to acquire it, tried to develop it, went through various stages, had some challenges, and therefore brought in some private equity partners to spruce it up, to make it strong. But at some time in the past, it was facing challenges and needed capital injection. Indeed, had an agreement with E&P for it to essentially acquire the mine for an agreed $100 million and possibly some of its liabilities. Agreement was signed October 2023 with the caveat that some payments will be made. First payment 30th June 2024, second payment 2026 June. Now, here are the issues under contention as far as I am concerned based on reading everything. Before December ended 2024, the Azumah Australia, I use the word purportedly, terminated the agreement because, according to them, E&P had not made good the first financial obligation, which was to make at least $50 million available by 30th June. Now, E&P is contending that by some communication they had with the company, the deadline for that first tranche had been extended from 30th June to 31st December. They even sent an email to us showing this. So that's another point there. E&P is also claiming that Azumah Australia deliberately frustrated attempts to execute what is called an EPC, which is essentially engineering, procurement, and construction contract. Basically, some work that E&P was supposed to do as part of the agreement, because don't forget, Engineers and Planning is a construction company, so some of the work they were doing to develop the mine would then be translated into shares. They are claiming that the company they were trying to buy the shares from deliberately frustrated that effort. They also said that in good faith, they did a number of things because the company was struggling. It hadn't paid some of its tax obligations amounting to around $4 million or so. And somewhere in 2023, they used their influence to get the GRA to back down on its serious attempt to collect those monies from Azumah. And they believe that they've spent at least $5 million already on this company. Right? And there are other issues. So, Bright, this is a quick summary. It's a very complicated matter. But I don't know that this summary makes sense for you, so we can move from there. Right? So, what is your interest in this, and when did you begin to seriously think about this matter and write about it?
So, I think first we have to establish that, like you started with, mining is a very different kind of industry in Ghana. It's a highly regulated industry. Yeah. The government owns shares in every mining company. Mm-hmm. So every mining company has a public interest. Secondly, because as you said, the Constitution says that all soil assets belong to the government, including even groundwater, mm-hmm. you are not allowed to just do your business the way you like it. Everything has to be regulated. Even how you hire people, how you secure contracts with suppliers, everything is regulated. You have to send everything to Minerals Commission regularly, reporting, etc. Secondly, we have environmental catastrophe on our neck because even with all that regulation, there's still a mess in mining. And the permit regime that says the Environmental Protection Agency, authority, all of these entities must play a role, tell us that mining is special. So there can never be a mining issue that somebody cavalierly refers to as a private matter. There's no such thing as private matters in mining. Every mining matter is a public interest matter. So that's number one. And therefore, for a very long time, we've been, as IMANI, working closely with the likes of the Africa Center for Energy Policy to look at the natural resource sector, the extractive sector in Ghana, and to comment. And to be very honest, this is not the first time we've engaged in this. I have been here in your studio a number of times, fighting over different extractive resources matter. I must also make it emphatically clear that some people have said, it appears as if we are only vocal when foreign interests are threatened. And that's a complete lie. You know yourself that in the matter of ECA or ACA, the ACA matter, this was a Norwegian company that we were trying to pay more than $1 billion, $1.6 billion, for assets that we thought were worth very little. And in the end, those assets had to be sold for $1 so that the company that inherited Africa Finance Company will inherit the liabilities. So our advocacy was proven right eventually. And there's been also instances, in the lithium case, for instance, which I also think we discussed in another of your fora.
The Awoya matter.
The Awoya matter, where you have a company that is controlled by foreigners that is looking for concessions in Ghana. And we have been some of the most vociferous in trying to insist that Ghana has to get the most out of it, insist on local refining, etc. So it's not true that we kind of are proxies for foreign interest. We've always had an objective stance when it comes to these natural resource matters. And we have had long-standing interest. Ghana's first oil discovery, Tullow, Cosmos, and the rest. Few organizations in this country provided an ongoing and continuous commentary, including our argument that the way that they went about the fast tracking of the development of Jubilee Field will affect productivity and prospectivity, and which now we are seeing some of the downstream effects very many years later in terms of falling production. So that was by the by. In terms of the specific issue around Azumah Resources, I'll be very honest with you. There are so many natural resource matters, and we cannot handle all of them. So some of them will come on our radar. In this case, you pointed out that I had been sued for commenting on another mining matter concerning engineers and planners, E&P. And therefore, people started sending me information about engineers and planners. And one of those pieces of information concerned an arbitration in London between this company and Azumah Resources. But in the course of investigating what is at stake, I then discovered a leak of the confidential material that had been submitted to the arbitration, as well as, fascinatingly, an attempt to host an event at Marriott Hotel on the 7th of July, where the letterhead of Azumah Resources was being used to invite people to come to the event at the Marriott Hotel, purporting to suggest that Azumah Resources was signing a deal selling itself to E&P, financed by the ECOWAS Bank for Investment and Development. And that immediately triggered some alarms, because it triggered an alarm because if this company is fighting Azumah in court, in arbitration, then either that matter had been closed or there's been further development. So I checked to see, and I realized the matter had not been closed. In fact, we have information that appears to suggest that E&P had actually been dragging its foot in paying the bills. That when you go to arbitration, you split the cost in order to accelerate. We have not fully confirmed, but this is information we're receiving. So that immediately made me very worried, because if you are in a dispute with the company, how are you able to get that company to invite people to come to a press conference, where at that press conference to be announced that that company is handing over its very valuable mine to you, and that a very prominent bank, the ECOWAS Bank for Investment and Development, will be financing the asset. So we probed further, and through our networks, we began to discover that something really bizarre was going on. I mean, this is one of the most bizarre investigations I've ever seen. It turns out that the company had not authorized the event.
Let's take it one by one. So you're saying that the arbitration is pretty normal, right?
Yes.
There are always cases between. So what piqued your interest was the fact that even though the arbitration was between E&P and Azumah, yet Azumah letterhead was used to write to invite. I just want to clarify, is it Azumah Ghana or Azumah Australia? Because there are two companies.
So Azumah Australia was founded in 2004. And in 2005, Azumah Ghana was founded. And Azumah Ghana its only important asset was a reconnaissance license that had been granted it to explore for gold. And Azumah Australia more or less owned Azumah Ghana, in the sense that the entity that had been set up in Australia was primarily to raise funds, and the one locally was meant to mine the gold, or find the gold and mine the gold. And then in the course of time, the person who started this the entrepreneurial mastermind who started this whole thing is a gentleman called David Harper, who is actually still active in Ghana, runs a company called Joe Drill. Okay. But in the course of these, that's how it happens. Very few people have the resources to go into a mining situation where they fund everything all the way to production. They have a very big company. So for a lot of entrepreneurs, people that are not already very wealthy, you go in, you start looking for the gold, you raise more money, you look for more gold, and you have to get the gold to a certain critical mass before you can build a large-scale mine. That's what people don't get. That's why Galamsey is rife. Galamsey is rife because the process of getting enough gold such that you can build a large-scale mine which can afford all those environmental protections is very, very laborious, lengthy, and expensive. So a lot of companies start that way and then raise money along the way as they find the gold. And then when they've reached a point where there's enough gold for you to build a commercial mine, that's maybe a 7-year lifespan or something like that. Somebody then comes in and then typically puts in the money. So this company has been doing that for a period. And then at some point in 2020, this company this fund called Ibarra Capital managed to acquire them completely from the Australian stock market. So basically they bought Azumah from the Australian stock market, which gave them access to
bought Azumah Ghana or
Azumah Australia from the Australian stock market. But remember that Azumah Australia owned a big part of Azumah Ghana.
Azumah Australia is part owner of Azumah Ghana
at that time. Okay. Then they created a fund called IGIC, which bought the rest of the shares in Azumah Ghana, and then they became 100% shareholder. So this Ibarra Capital is the one that also owns the fund in Singapore called Kango, which owns the other companies, which own the other gold project we won't talk about at all because it's not under dispute. So more or less, the real entity we are dealing with is Ibarra Capital because it owns the 100% shares in the Azumah Ghana.
Even though they are not listed in the arbitration by name, because in the arbitration you notice that the E&P lists 6 respondents and they list the specific entities they
dealt with. These are the ones they signed a contract with.
Which is my point.
So
Ibarra is almost like the financing conglomerate behind.
It owns the shares.
Yes.
So basically it's a controlling entity.
I'm saying this because when you go into the the list you yourself put out on your site in terms of the directors of the companies. Now list individuals.
Good.
And does not mention
their affiliations.
You know, and if you go to the company's register, so it mentions specific individuals.
Very good. So normally what you do when you are a fund and you invest in a company is that you need to put human beings in the company to exercise control. And some of the nominees, for very big funds, sometimes you have maybe a junior associate go and sit on it. But for smaller funds like Ibira, which doesn't have a lot of portfolio companies, usually the senior partners themselves go and sit on the company's board. So James Bank, who you've seen in the famous letter that was issued, is the managing partner of Ibara Capital. And he is now the board chair of Azumah Resources because they own the company. And then he brought initially all the directors. But, and we'll get there soon, later on, E&P signed an agreement with them in October 2023, as you've mentioned, which required that they work together to build the mine, raise money to finance the mine.
Okay.
So for that reason, because to have a transition period, they require that, rather E&P required that a board resolution be issued, which will then lead to them appointing 2 directors to the board. So it became a matter of majority-minority. So you have majority directors, minority directors.
So World Bank is a director of Azumah.
Is the chair of Azumah, so to speak.
Then
and
there's
is
a guy
managing
called
partner of Ibara Capital, which is the entity that owns Azumah Resources.
Then there's a guy called Jonathan Hronsky.
Yeah.
Then there's one Amwakwata.
Yes, in the beginning, Paul Amwakwata.
Who I am told is deceased. I'm not sure.
Yes.
Then there's one Hector Nyinako.
Who is the secretary, so he's not a board member, though it depends on company. In Ghana, typically
company secretary he's like a beneficial owner.
He's official. Yeah, he's handling the beneficial ownership in trust. Yeah.
I'm bringing this up because you said that the invitation to the EBID program was a bit bizarre.
So the invitation
because of course World Bank will not be at that event. There were the 2 local directors
who were E&P representatives
on the board.
But
I'm also told that Nyinako was at the event.
That the secretary was at the event.
Yes. Who is described?
But he's not a director.
E&P describes him as the beneficial owner of the shares of the other shareholders.
In trust.
He was at the event.
Normally, for an overseas entity, overseas private equity fund, you set up something in the Cayman Islands. You have a trustee.
Yeah.
So it would be typical for the trustee to play certain kinds of roles. If he was at the event, or what was his role? He's a secretary.
Yeah, but you see, I'm saying this because if it's bizarre for E&P to, or for, what do you call it, for Azumah letter to be used to invite people to an event, why is the company secretary at the event? It doesn't invalidate the event.
No, it
doesn't 2 other board members. So in a sense, you have 3 people.
No, because in the end, the company secretary is not a voting member. So he's not part of the majority of the board. You understand what I mean? The company secretary in the Ghanaian
But if the company is dissociating itself from the event, why is the company secretary there? You know, because if a company has written to say, we have nothing to do with this, this is a purported shareholder, whatever.
Yes.
The company secretary should not even come.
We don't know whether the company secretary was there or not. This is information.
This is what E&P is telling us.
Yeah, so we don't know for that.
You are not sure.
So let's
but we know that two Ghanaian directors were there.
So for that, let's pack that. Because we can check.
You dispute that?
I don't know. So we can take the video and we can examine the video and look at it.
All right.
So they claim that the company secretary was there. So that's one issue we'll look into.
But is there a difference, just clarify, is there a difference between the board that the 2 Ghanaians are on? And these 2 Ghanaians I'm referring to
Noel Addo and
Nana Benejumo. Are they on the same board as James Bank and Hector Nyinako and Jonathan Hronsky? It's the same board?
Yes, the board had to be reconstituted to allow the transition.
Good. So I'm checking. So the board has Nana Bene, Noel, James, Hector, Jonathan Hronsky, and 1 Stephen.
Okay.
So 1, 2, 3, 4, 5, 6.
The critical element is that the company secretary is not a member of the board.
In this particular case?
Yes.
But in some cases, company secretaries are members of boards.
Your bylaws could indicate that, but it's very rare because of corporate governance issues. Typically,
So I'm saying
that's one issue.
So we've heard from James who says this is a sham.
So that's
Nana and Noel are there.
I'll come to that.
Hector is there, but you're saying he's a secretary. So the only
but I don't know whether he's there or not.
Fair enough. Then there's Jonathan and Stephen, who we don't know where they are, and we don't know what they think.
Very good.
Because they haven't said anything the whole conversation.
No, I'll come to that. So that comes to the next level of corporate governance.
Okay.
Who owns the company?
Correct.
All these directors serve at the pleasure of the shareholders.
Okay.
So tomorrow the shareholders can decide to fire the directors. You understand that, and there's no dispute.
Yeah.
So when you go to who owns the company, the 2 companies that are listed are Azumah Resources, as you've seen yourself, and IGIC. IGIC is a fund of Ibara, And Azumah Resources is owned by Ibarra because they acquired it on the Australian board. So any director who is serving must be serving at the pleasure of the shareholders. The only reason you have the two Ghanaian directors representing E&P was because at that time E&P had acquired a notional interest in the company, given that they were helping the company to raise money.
So if you've put the two, if you allow E&P to put two members on your board,
yes,
it means that you've agreed that they are in the process of acquiring some shares.
No, they are in the process not only of acquiring shares but building the mine and raising funds. You understand? So we as a company are going to go out and raise money and build a mine. E&P is a construction company, it's a mining operating company. So we have a strategic partnership with you to help us.
To raise money, but also to do some
to
construction work.
To build the mine.
Yes.
And then operate the mine. Because E&P operates the mine for people.
So those two Ghanaians are on the board working for the...
They are working for the company's interest.
So which means that there's an intention that we are coming together.
We are all working together.
If you make the payment.
Not only that, we are all working together to grow the value.
Of course,
because
but you have to raise the money.
Yes,
those are the two.
You are responsible for raising the money. And what I'm trying to explain earlier was that this is natural. A lot of people go into mining with half the money, 1/10 the money, whatever. And as you show validation that the gold is there, whatever, people come in. It's called earn in.
Okay.
So E&P has come back. You've come in more than an earn in contract. What do you call it? Shareholder.
Okay.
You've come in as a strategic partner.
Okay.
You are going to help us raise money. Also, you have connections in Ghana, which nobody denies. That will help us with some of our issues. You help us build the mine, etc. So it's a relation of trust.
Good.
Because of that, brings some two people to come and work.
Good.
So they set up a technical
and they started working.
Very good. I'm coming.
Yeah.
So they set up a technical committee, and they say, E&P, you are the contractor. So you handle the technical committee, chair the technical committee. Finance committee, you are the ones raising money. So have a bigger role in the finance committee. Everything else, project board, right? And the project board is chaired by Ibarra because they own the company. So let's start off with the critical element because it's easy to get distracted. All the time that all these Australian people, Ghanaian people, it's not only Australians who did all this work. There were Ghanaians who were involved in the very beginning, helping, what do you call his name, David Harper, to do this work. Some of the any concessions that came into this company came from Ghanaians who handed it over to the company. So many things Ghanaians have done, as well as supplies and things like that. In fact, there was a time when David Harper signed, as Joe Drill, signed a $3 million deal to provide the drilling services, which was what has been led to discover the gold. People say the gold was discovered in 1992. The gold was discovered in 1992 of a certain quantity. Kunche deposit had a certain quantity that was known. I think at that time, the proven reserves was more around 200,000 ounces or something like that. Over the period, all the work that has been done has led to the total amount of proven reserves, the amount of gold you can actually dig out there and sell, to increase by almost tenfold. So a lot of value had been created before E&P showed up. Okay, so the point is let's continue to increase that value, right, by building the mine and
also raising money. Let's take a break. We are on the same page now. This is the point of view. My guest is Bryce Simmons. I'm playing the devil's advocate because the other group is not here. We've agreed to do this. We want to throw more light on the matters. So at least we've established that there was some relationship between the two organizations, which you can say was not fully consummated, using biblical English. When we come back, we'll try and plow into what makes this arrangement so murky. And more importantly, from a public interest perspective, how can this be solved for the best interest of Ghana? Because I think that's where we're all coming from. Exactly. So stay with us. We're still on the point of view live with Bryce Simmons. And Bryce, typically, as we go, people keep sending messages. Now, maybe I need to read some of the messages I've received from Bobby Bunsen, who is a lawyer for E&P, who says, please, E&P paid the original $65,000 requested by ICC. So that's what he's saying. Number two, Hector Ninaku is in the pictures. So apparently they circulated some pictures for the event that happened on Tuesday. I don't know.
I'm going to wrap that up. Let me wrap that up.
Yes. I don't know Hector, but he says he's in the pictures.
I mean, the issue is very simple.
Yeah.
In corporate governance, you got directors, you got owners. Directors serve at the pleasure of owners.
Yeah.
E&P was allowed to nominate members to the board, despite the fact that it wasn't a shareholder, purely out of courtesy, because typically the owners control the board. Ninaku is a secretary. Secretaries in Ghana are typical members of the board. They are ex officio. So they sit in and take minutes, they comply, make sure compliance is settled, etc., subject to the bylaws. In this company's bylaws, the secretary is not a member of the board. He can deny it. So that is what he should answer. So if that is the case, then you have got 3 board members versus 2 board members. And then the owners who can fire the other 2 board members, unless a court stops them.
You can even say 3 board members versus one who we haven't heard from. Because the Hronsky guy, from all the reasons, hasn't said anything.
He works at the Barra Capital. He can't say anything.
That's what I'm saying. So I'm trying to say that if there are 5 board members, 2 are there, 2.5, because one of them is not a board member.
There are 6. One of them is not a board member. The 5. 3 are Barra Capital, and they work for Barra Capital.
Okay.
To the extent that they work for Barra Capital, and the shareholder is the Barra Fund. The managing, there are rules of the fund.
So are you saying that the secretary is there at the place of Ibarra?
The secretary.
Or was he nominated by E&P?
No, the secretary is there is the secretary of the company. So
who put him there?
It has to be the company acting by resolution.
Anyway, let's move on. I'm just putting that
out. The company, the point I'm trying to explain is that, first of all, there's a majority of directors, which are still controlled by Barra. That's an important point. The second one is that the ownership of the company at the registered general, I've sent you the information because I did my checks. Before I could go out and put my reputation on the line, I had to be sure what I was talking about. The checks that we've done at the registered general shows that the ownership of the company is still IGIC and Azumah Resources Australia. Both are owned by Barra, which is a fund. Now, therefore, the shareholders of the company are the ultimate decision makers in this matter. And the directors serve more or less for the shareholders. Now, the point I was making is you cannot go ahead and decide to do an event and announce such a consequential matter without authority from the board. So it's a very simple matter. Did the board meet and decide we're going to take money from EBID or not?
But the board is split. From what we are saying.
The board is split, but...
So we don't know whether the board, how the board...
Okay, but it's a standard corporate governance matter. Who owns the company? That's your first point. The second point is that what's the majority of the board? The majority of the board, the 3 of them that you've seen, are Ibarra Capital people. So we shouldn't really, I don't think we should dwell there too much. There was no board resolution authorizing this decision to go and raise money from EBID. E&P does all this. I'm coming on. That's one last point. E&P does all this based on an agreement in October 2023 to come in and in good faith and in trust help to raise money and build a mine. Now, the question that concerns us is what happened thereafter. What happened thereafter is that that agreement was terminated. They don't dispute that.
They say it was unilaterally terminated after communication clearly showed that they agreed for the financial threshold to be met on a different date. Do you understand my point? So you are supposed to provide some money by June 30, 2024. You were not able to do it. You communicate with the principals who say you can provide, according to them, they sent an email to show this, that we've moved the deadline to 31st December of 2024. Before 31st December, then you issue a letter that you've terminated. So they believe that. So in their claim for the ICC, they claim that the termination is not valid.
No, but by the time they sent the matter to ICC, the termination has not been issued. So it couldn't have been that. If they told you they claim in the ICC, whatever, that cannot be true. The critical matter is very
Sorry, what cannot be true?
The termination happened in December 2024, right? And the matter they sent to arbitration was 2 months
to preempt that.
Yes, but I'm saying that the termination hadn't happened. So it couldn't have been an issue.
Listed in the termination, yes.
So what I'm trying to explain is that the decision around terminating the agreement was not based on one ground.
Okay.
It was based on not being able to meet the first deadline for raising money, which was for paying their consideration, which was the 30th June 2024. But it was also based on the failure to enter EPC agreements.
Which they also claim was because, again, you notice from the paragraph that 26, 24, 25, that the first respondent deliberately rebuffed attempts to basically get the EPC to kick off. So they are blaming...
So that was the standard commercial dispute. But nobody denies that there were agreements in terms of when to do things, certain things you have to commit to do, etc., which were not done. E&P suggests that, okay, we had good excuses, and we'll come to that in a minute. The third thing is that...
You call them excuses, they can say their reasons.
Well, we'll come to that. The third thing is that trust had also been broken because E&P had gone ahead, and this is basically me reading the legal agreements, and now going further, and with some interesting digging, getting bank records to also prove this. That it turns out that E&P set up a bank account contrary to resolutions to make that bank account controllable by Azumah, and continue to control that bank account through the signatories that were their directors they put there. So all the money E&P was putting in the company was going to a bank account that only they controlled, and they spent as they saw fit. And I have seen information that suggests that some of that money went to our good friend, Mr. Banson, for legal fees, etc. I cannot see how Azumah Resources will be paying Mr. Banson as part of fundraising and things like that, for him to go and represent their adversaries in our arbitration. So these were all spending related to the interests of E&P. And if you do that in a situation where we are supposed to come together, set up an entity and go and raise money and things like that, you break trust. So I'm coming on. So once they discovered these matters...
Are these listed in their response?
This is listed in the court proceedings in Ghana.
Okay.
Because remember that
yes.
there were several court proceedings in Ghana which are still pending. For those only one decision, interim or interlocutory decision had been taken.
The injunction was granted?
Injunction. No, the injunction was granted in parts. They went there asking for plenty things. Stop the resolution, the dissolution of a finance committee. So do all manner of things. And the judge said, I can't do all of these things. And he said the couple of things I should do, basically to preserve the order, is to prevent the company from being sold, etc. I sent you those documents.
Yes, I'm just trying to inform listeners. So the Ghana court has not stopped E&P from continuing what it was doing in terms of its relationship with Azumah.
No.
It hasn't stopped them.
No, it has stopped them in part, because when they went to court, they had a list of things they wanted the court to prevent
the other
guys from doing. And those things will have more or less preserved the status quo before termination. The court was smarter than that.
Okay.
And decided to say, no, rather I would give a ruling that will not prejudice either party by preventing that one.
So it's almost like it's preserving the status quo.
It's preserving the status quo, but not the status quo until not the status quo before termination. So essentially, the court doesn't say that the finance committee cannot be dissolved and all of these other things. And it will be good for you to pull up the ruling of the court and take a good look. Okay. So in all of these matters, the critical thing is I got involved because I saw evidence that somebody was attempting to claim that Azumah Resources had agreed for their mine to be sold to E&P, and that EBID was coming on board in order to provide the resources for that to happen.
Yeah.
And I thought that was untrue. And that was a very strange problem. Why? Because EBID is a multilateral development bank.
Repeat that point. Repeat what you just said.
I got involved because somebody using the letterhead of Azumah and the rest to invite people, creating the impression that Azumah has consented to the Black Volta mine being sold to E&P. And then EBID, which is a multilateral and international bank, is coming on board. It's an African multilateral bank. Is coming on board to finance that program. Now, I was interested because of two angles. One, we have been studying on behalf of the World Economic Forum the global financial architecture for aid and development. And one of the pieces of that is the multilateral development bank, so the World Bank, the whatever. We've observed that some of the smaller, newer African multilateral banks, Afrexim Bank, EBID, etc., they operate in very murky and non-transparent ways. No, that's the view.
So you are agreeing with credit rating agencies against our noble development finance institutions.
I'll give you a very practical example. You are one of the...
AFDB and...
No, AFDB is solid. AFDB operates on...
Afrexim has an issue with Ghana.
Bank and this particular one, EBID, which was...
Has it been historical or just recent?
I'll come to that. Afrexim Bank, my issue with them, or I started to have a concern with them when Afrexim Bank gave Ghana money and we couldn't find any documents. And I had to go through Parliament to even get a hold of the loan. That would never happen with the World Bank or with AFDB or any of the old multilateral development banks. You were here in this country when that deal was being done. Yeah. You go to the Afrexim Bank website, you see any information. It's not standard. Most multilateral development banks, you go to their website, they display all the projects they are doing.
Fair enough.
EBID is the same. You want to look for information on projects they are funding, why they are funding the project, what was the environmental studies, impact analysis, etc. You can't find it. For EBID to reach this point where they claim they are finding a mine, in a traditional multilateral development bank, the amount of documentation would have been generated if it was the World Bank or IFC involved. The amount of them would be unbelievable. It would all be on the website. I can't find that information. I reached out to EBID. They refused to answer. This is not standard multilateral development bank. All that triggered my concern. Even E&P, I have a standing request.
So you're saying that their lack of
transparency
is not necessarily specific to this transaction.
No, it's a pattern of behavior.
It's a pattern
which
of behavior.
I've been studying before and I've written about, which you know about. I've published about this matter. And I'm saying that even with E&P...
So are you saying you believe it's an error of judgment for them to extend 130 million to E&P?
No, it's an error of judgment for them to be non-transparent about it, not to explain.
That's the general point.
I'm
talking in the specific, you said there were two issues.
Well, in this specific case, I've written to their president asking for information, he just ignores it.
Written?
Yes.
Officially?
Officially. It's the same also with E&P.
But you confirmed that he received the letter?
I don't know. In the case of, but I sent also information to his private number, etc. In the case of E&P also, we have a standing request from the owner of the company to provide information if they think anything we are saying is somewhat contrary to the facts.
Okay.
I've sent that information to him.
I've
actually met him
at
some point, prior to my publications, met him, my latest publications. And in my view, the reason why I'm very concerned is that I see a tendency to be non-transparent, as if these matters are not public interest matters. And my argument is that they are public interest matters. Because the minerals belong to Ghana, the permit, I'll give you a very practical example. In the latest release by E&P, what did they say? They said they have a no objections certificate or the document from the Minerals Commission that they can go ahead and do what they are doing. So that's the government authorizing them. So when people say that this is not a political matter, this is not it's too private, they don't understand what they are talking about.
Right.
Everything we do in this country in mining, you can't do it if the government doesn't allow you. So
I just want to come back to the point I asked you to repeat on the EBID. So again, I'm reading the document that, what do you call it, E&P put out.
Yes.
So they put out a press release claiming that a top executive of the shareholders of Azumah from Australia accompanied officials of E&P to Lomé, Togo, to visit and hold discussions with EBID towards the project acquisition and development. This is obviously prior to things going south. Okay.
Okay.
So I'm coming. I'm trying to say that they are suggesting that
Azumah is involved. Okay.
That Mr. Was it World Bank?
Is isolated in his own company. It's isolated in the fund.
No, let me make the.
Okay.
So they are saying that to make it seem as if EBID is advancing money to this project without the involvement of key people among the shareholders.
This is not how we do it. Why? Ibarra is a fund. Funds have mandates. They have a governance structure.
Yeah.
The Ibarra fund owns Azumah Resources, both Australia and Ghana.
Yeah.
They are 100% shareholder. It's not that they are 5%, they are 100% shareholder. Nobody disputes that. You cannot say I got some director from coming.
But they've signed an agreement with.
I'll come to the agreement in a second.
Right, they've signed an agreement with E&P.
Yes.
That E&P can assume ownership of some shares. And therefore, that gives them the money to go and raise money. They've gone to EBID with these documents to raise the money. At the beginning, with directors of Ibarra.
Okay. Let me explain that cannot be correct. In the sense that, one, the EBID, before this event, I have seen copies of documents sent to them. You know, that unknown to them has leaked as well. And we just don't want to, it's not everything that leaks in a corporate document, you just blast all over. That shows that EBID was aware that there was a dispute over the asset. Which serious bank, forget about multinational banks or multilateral banks, even gets a document like that telling you there's a dispute and doesn't pause and say, okay, let me talk to these people. My information, there's one gentleman for Azumah in this country who spoke to somebody else in the media. And I have a copy of the transcript, which suggests that when they wrote to that entity, to EBID, they did not even bother to respond. And up to date, they have not bothered to respond. If you're a serious bank and you want to fund an asset and the owner tells you I'm not selling the asset, you don't dispute they are the owners because they own the company. They are the only ones who have invested money to get the company to where it is. Because any money that, what do you call their name, E&P says they have invested, was after the mining resource reserves were all declared. So where we are now, the 100 and something million spent to get us to where we know there's good and the rest of E&P was not involved.
Right.
And that company says that I have a problem with the thing. Why do you go ahead and do a launch and sign agreements?
From all we've been discussing, there's obviously a division in the board, whether it's a project board, committee, or the main board over what to do. So that's clear. Are you saying that a serious development bank will not do any analysis?
When there's
I'm coming. Whether it's political risk analysis or whatever analysis.
When there's active arbitration,
but
where everybody, even I, who is not a party to it, can go to ICC and see it's listed. When there's pending court proceedings, I'll tell you, even a service and loan company in this country told about these matters were exercise forbearance. They will say, let me wait and get information. At the very least, as part of the due diligence, they will talk to the owners.
But maybe
it's not possible to do due diligence for an asset that you don't talk to the owners. It's not humanly possible unless there's something else driving you, there's something else motivating you. And I'm challenging EBID, including the director, George Jikum Danko, that if indeed he did due diligence and he didn't talk to Ibarra, then he deserves to resign. So he has to prove that somehow he engaged Ibarra as an entity.
But so far,
it's not possible to do it.
All we've been told suggests that this was all going well until somebody...
That is why I didn't get involved until the event. It's the event.
You are not even, let me ask you a question.
Yes, ask.
See, what I'm saying is that the thing started in 2023.
Yes.
A lot of things have happened until a termination.
Okay.
Some of that work should count for something.
I agree.
That's point number one.
I agree.
So relations have been formed. Number two, we also agree that even on the board, there's a division as to what to do.
Okay, I agree.
So, so if you're a bank, it depends on who on the board you talk to.
So
I'm coming on. So I'm saying that to ignore those, that history, and to suggest that maybe EBID just willy-nilly decide to give the 100 million for shaggy reasons may not be fair to them. Because EBID has not...
EBID is actively participating in the disinformation campaign, is what I'm suggesting.
In what way? Have they made any statement?
In May 2024, they presented a term sheet to Azumah Resources, to E&P, which was presented to Azumah Resources. And Azumah Resources said, based on the agreement, it is not compliant because it doesn't show that the investment committee has approved it and it's a final approved document. It shows that something is indicated.
So did they send a refined term sheet? Did they send a reviewed term sheet?
A month later, they did another refined term sheet.
No,
but then that term sheet was still not compliant.
Yeah, but I'm saying that
I'm coming. I'm just trying to explain that if you're a bank and it's very clear that the entity that you are trying to deal with is resistant, and there are people in there who own the assets, that's the big part. You have to start off with who owns the asset, and you have to talk to the person who owns the asset. You don't talk to the person who owns the asset. You keep doing your thing. And then you get to a point where the year later, you fly from Lomé, show up in Accra, go to a hotel as the president of a major international bank and participate in an event, which later the owners of the asset that you claim have been sold come out publicly to disown it. In some jurisdictions, this person will resign.
Fair enough. But
it's a total scandal.
You keep talking about owning the asset, but don't forget at the beginning of the show, you also said that all these assets are, you agreed with me that they are held in trust for us by the government.
True.
So is it Lebara or Ibarra? They are the owners of the asset for a period.
Yes.
Now, you can also discount what the regulators have started from 2023 because regulators are the ultimate owners of the asset. And they all, I'm coming.
Ghanaians are the ultimate assets.
No problem.
But we sell rights.
So what I'm saying is that if you can elevate the role of the owners of the asset, you should also whatever Minerals Commission has said or whatever the government regulators have said should also count for something.
I agree completely.
In this conversation.
I agree.
And,
but in that instance,
they also seem, just give me a second, they also seem to be on the deal.
No, I don't think that one we can't say that for sure. Because the only thing we know it's E&P saying in their arbitration submission, their request for arbitration document, that they have influence at GRA and they have influence at Minerals Commission, and therefore they solve problems for this company. This is something that, when I suggested that in an earlier article, they sued me for libel. And when they sued me for libel, they mentioned that as one of the things that offended them. They say it plainly. But the company is also claiming that the problems that they purported to have solved around with GRA is a non-sequitur because they were the ones who ultimately paid the money and then the rest was waived. So the only thing we can infer is that E&P is powerful enough to get GRA to waive some part of the money. Because if they paid part of the taxes and the penalties were waived, and you claim that it was due to your power that was achieved, then we can suggest that you have some influence. But that does not suggest, though, that the government has publicly come out to say that strategically this is this direction, and EBID is backing that. Because why? For that to happen, the government needs to nationalize the mine and expropriate it and be willing to go for international arbitration. Until that has happened, the government officially expropriated the mine. You, as an international bank, cannot claim that disputes
let's take a breather.
Asset is not,
let's take a breather. I think I need to,
matter.
There's a lot more questions I have for you. This is the point of view. And look, Mr. Simmons has agreed for me to be his devil's advocate. So I am not a devil, neither am I an advocate, but it's a term of art. So we'll see how it goes. We're trying to bring more clarity to this very controversial issue, which is at arbitration, right? Do we know the date the matter will be heard? We are not sure, but basically we know it's still at arbitration. There's also a court case which is, you can say, partially determined. So stay with us, we'll be right back. This is the point of view. Tonight we're trying to get into the heart of the attempt to acquire Azumah, not the boxer, but the mine. Incidentally though,
he has a connection.
Yes, we were told that apparently when Azumah beat Jeff Fenech, beat him so well,
David Harper went to Australia.
David Harper says, no, I like Azumah, so I'll call my company Azumah. And Azumah was at the event too.
Yes, Azumah was
Should that count for something?
Spiritually, yes. The Zunzun warrior can do no wrong.
There is a view that this is all about greed. The Herald wrote a story and said, these guys have agreed to sell an asset which they bought at a very low price. So let's just forget the technicalities. Let's just ask basic questions.
Yeah.
When they took over the asset, I don't think they bought it for more than $50 million. All right? Because I think they injected an initial 13 and a subsequent amount. Okay. And they said they'll sell it to E&P for $100 million and take our liabilities. Now, they are making a big windfall. The whole conversation, according to the Herald, is that because at the time they sold the asset, they were distressed and gold prices were low, they thought they were selling a bad asset to a stupid African man. Now gold prices have doubled, and some other people are expressing interest. Some people want to buy for $300 million. And all of a sudden, they've said, no, we're not going to, we are going to scuttle your attempt to raise the money. It seems plausible, doesn't it?
Well, Bernard, you and I are not naive. Business people are not saints. And we are not here to hold the candle for Ibarra Capital or Azumah Resources or any of these companies. They are not saints, right? They are there to make a profit. And the bigger the profit, the better.
But should their motives not be questioned?
Yes, absolutely.
Because in terms of how they take our resource, we should also be concerned.
Absolutely. But then we have to do that across the industry. It is not when we are not disputing specific circumstances around an attempt to strong-arm them or to muzzle them.
But somebody said, no, because you see, they said they also doing questions. No, not right, because somebody can also say that they are also trying to pull a fast one. You were in trouble, you came to a company, the company helped you sort out your problems. They said we invested $5 million in doing stuff. They are almost raising $100 million, and then gold prices are going up. Then you say, no, I'm not going to sell again. Okay. I want to sell to somebody else. Is that also not taking us for granted?
So one, they dispute the fact that the company used the $5 million on anything related to the company because they claim they put it in an EcoBank account. Problem. That money has been spent on their own things, including for their very expensive lawyer. That's what they say. So you spend the things on things that are not relevant to growing the asset value. Number two, they insist that, by the time that we came to you, it wasn't as if, we couldn't solve our issues because when you went to GR and the rest, in the end, yes, we asked you to help, but we ended up paying those liabilities anyway. So it's not as if you paid it on our behalf or anything. So that's important that we put it out there. Three, there's no dispute that E&P was considered a very important strategic asset to that.
At the time the agreement was
signed. There's no dispute.
Yes.
Because you can see from their prospectus and everything else that they hyped the fact that E&P was a very big mining services contractor and all of that, etc. So there's absolutely no dispute. That is why I'm very worried because the actions of, I don't think Mr. Ibrahim Mahama, who is the owner of E&P, is being well advised. Because some of the course of actions going forward is damaging the trust in the relationship and the value he's built.
But
even his decision to sue me, his decision to go to arbitration, all of these things appear as if I'm coming on.
I'm coming on. See, if a company has been offered the right to buy a mine for a certain amount and is taking the trouble to raise the amount near to completion point, and then you sort of terminate.
It was not near to completion point. And the reason is there was a fundamental disagreement about what the different parties had agreed to in the beginning. The company, Azumah Resources, wants the money to be raised on the books of Azumah Resources, or if the money is being raised for on E&P's books, then the money must be invested as equity. Why? Because they are not determined that they want to exit completely. They want to see the value build up over time, which is the whole point. So come and be part, let's grow the value, which is the whole thing about mining.
So what percentage was the 100 million?
The 100 million was for the issue shares. And the issue shares at that point, you know the way company law works, you can issue additional shares to grow it. The rest of it was supposed to be on a vesting schedule. As you build the mine, then you get more shares. And you could see that $1.2.8 per share.
Are you saying that they were not interested in exiting? Because
not immediately. No, if you read
because it appears they were distressed.
That is they were not distressed. That's not distress. You have to read the agreement. I don't know who read the agreement and explained it to Mr. Mahama. The big problem is that he wants to raise the money on his books and then acquire them and exit them. And that's not the agreement they signed. I don't know his oral discussions or verbal discussions them, but there's an agreement that I have carefully read, asked lawyers to read, explain to me what they think, ask other lawyers, etc., their opinion, synthesized. And the big problem is this gap is a big gap. One of them has to back down. It's not evident to me that the power dynamic from a legal and proprietary point of view is on the E&P side, because these people still own the assets, right? And now I use own advisedly, as you've tried to explain. It's owned by Ghanaians.
But time,
they own in terms
but the time is not on their side, is it?
Well, the time is not on everybody's side. If we want the royalties as a country, we all want this matter to be resolved. But it can only be resolved by the two parties, first of all, agreeing what is the actual business transaction. Where Mr. Mahama, there's a clear agreement that says this is how it must be done, but you want to do it in another way.
There are different views on what that agreement means. That's why they are arbitration.
Yeah, but I have.
So I'm saying, right, take your time. See, that's why lawyers exist. So I think
true. But that's the point I'm making, which is that there's a fundamental disagreement between the parties. When you have a fundamental,
this is normal.
True. So when there's that fundamental disagreement,
if it's normal, so you've said two things. You are saying that these companies are not saints, so it's normal for them to want to
maximize their interests.
So that's true for both companies.
True, but what are we talking about? What we are talking about is that where the two parties are not actually at a meeting of minds, then we don't have a deal.
So that's why they are arbitration.
That's the problem. Because if you try to force it through arbitration, then in that process, the due diligence requirements for EBID is not met for them to do a deal. But remember that we are having this conversation only because EBID announced that they have put $230 million available to fund the transaction. But you and I have agreed on this show right now that there appears to be a lack of a meeting of minds between the key people. So to my mind, EBID's involvement inflames the situation.
The agreement anticipates this because for every agreement, they say when there are issues of dispute, it will be done under arbitration and English law in their court. So but my point is that it is not strange to go to arbitration.
Yes, but I'm saying that this company started 2017, grew their asset base until 2020, they had 100% control. And for the further 3 years, they've continued to grow the asset value, which is basically the amount of gold being discovered. You understand? They've grown the gold being discovered out to the point where it's now a valuable mine that can be invested into. Mr. Ibrahim Mahama walks in. It is his interest.
No, they invite him.
Well, both of them decide to do business. No, that's not clear. Both of them decide to do business. If you decide to do business at that point.
If you read some of the, for example, the resolutions in the aftermath of October 9, it's very clear that these people were very eager.
Both sides were eager.
Just hold on. You see, what I'm trying to say is that let's not make it seem as if the company did not need E&P, because from up until the end of 2024, there seems to be an eagerness on the side of the owners to dispense of some shares to E&P.
No, that's what I'm saying. He was supposed to bring valuable service. So it's a very straightforward matter. The issue right now is that due to a lack of meeting of minds, that valuable service has not been delivered. And they have not raised the money. They've not done the mine development that they were supposed to do. Even the DRA Global Bankable Feasibility Study, which you used to go and raise the money, it was not done by E&P. So all of those assets that are proprietary to this company, they have done all the work, the bankability, everything that a bank needs to invest in it, they have done it. How does EBID sit somewhere and come and sign an agreement without talking to them?
Let EBID speak for itself.
No, because of the event. I got involved in this because of the event.
EBID can issue a statement to explain what they do. So I feel like we need to be surgical on the two parties, because EBID seems to be like...
But even for the two parties, you need...
They are taking out of stray bullets.
True. But even for the two parties, you need a meeting of minds. My point is, it does not make sense for E&P to continue to insist. Look, read their last agreement that we've got a certificate of no objection from the government that we should take over. We will take over.
Does it matter?
What kind of
does it matter when E&P says this takeover was agreed at a time when the owner of E&P was his brother was not?
Okay, let me clarify one other misconception, which is that it's the gold price that determines everything.
No, okay,
let me make that point. It's very critical. The time that they signed the agreement, the gold price, as you said, was a bit relatively low. The time they terminated it, the gold price hadn't gone astronomical.
Fair enough.
They terminated it, and then subsequently the gold price went high. What else have done is that by slowing things down, not getting trust and the rest of it, the circumstances the market have changed. But that didn't change before they terminated it. The change of circumstances happened, as you know, this year. That change in circumstances, commercial change in circumstances, happened after the termination.
Do we know if another company is interested in offering more money for the asset?
It's a good speculative exercise to say, which is the whole point about being greedy.
It can't be speculative. It has to be substantive in the
case. No, we don't know. That's what I'm saying. It's a good speculative thing to say that, look, maybe there's somebody waiting in the wings, counterbidding. But my argument is very simple.
But should that not be important to us too?
The critical thing is that there must be a meeting of mind where you can do business. I have something I've spent 6 years developing. The value of it has increased to the point that you are interested. We want to work together to grow it. We can't be fighting the media. The fact that you are issuing a press release, I'm issuing a press release, we are at arbitration, we are at court, tells everybody that there's no meeting of minds. So you don't go and stage an event that glows over it. That event is the heart of the problem. And the announcement and the purported attempts to claim that you still have done the purchase and that you've got the money and by hook or by crook they must sell to you. Yeah, but that's how we do business.
I still feel like
how we do business.
We need to give, because you see, because I didn't invite EBID to the program.
True.
You see, I'm very hesitant.
Yeah, so I'll stop
because I felt like I invited E&P.
Yeah.
And they did not come but send some documents. EBID, I did not invite.
So
I feel like they are taking a lot of stray bullets, which for a bank is not fair.
I agree. I'll
to
stop
them.
further references to
It's not
I will
fair
just say that
because we also do not know. You see, and you said we've not seen the due diligence part they took. So you can obviously question.
Let's put it aside.
Let me make my point. You can question the logic and the reasoning behind the decision they took based on the information you have.
Okay.
But because we don't know everything they know, I think we can leave them out.
I'll leave them out. And I'm saying that as far as E&P is concerned, there must be a meeting of minds to do a deal. That's the most important thing. I have an asset I've invested in, I have a license, I've done all manner of work. You are E&P, you want to come in and help. We must agree first.
Let me end with a question.
I'm coming. So if there's that meeting of minds is not there, don't go and do a big event, pop champagne, invite people, and
you've made that point.
You've made that point. I haven't sold to you. It's a very simple point.
This morning I read a story that President Trump was meeting presidents of 5 countries.
Yes.
Senegal, Gabon, Guinea-Bissau, Liberia, and another one.
True.
To discuss American companies essentially getting a piece of the mineral resources of those countries.
Yeah.
So the global context of this is that there's also a big fight
for countries to control their own assets.
Yes. So again, if you come from the perspective of people on social media saying, look, this is a Ghanaian company which is trying to, or which has built the capacity to potentially own a mine in the Upper West region. Ibera or whatever are essentially foreigners who have come to do something.
True.
So why shouldn't we be fighting for the Ghanaian? Basically, that's what it is.
Because,
for example, when we sold that mine, I think the Chinese got it. So a lot of countries are fighting for a piece of Africa's mineral wealth.
True.
So if an African company is even in the conversation, we should be supporting them.
That is why it pains me that they are doing things that damage the value they have, right? Because ultimately, even the Ghanaian companies in this country, they get technology from overseas. Zoom Lion started with technology from China, if I am correct. Suba Info Solutions, a big subsidiary of Zoom Lion, started with Indian technology, right? Companies like Mechanical, Lloyd, Camelot, all of them, they had technology partners overseas for a long period of time. Big companies like Casapreco and the rest, they have technology partners from abroad who come in and help them. Some companies in Ghana have raised money abroad. Some companies from Ghana have customers abroad they export to. The country's reputation matter, the individual player's reputation matter. You cannot be a national champion for us, E&P, if you do things that makes, even as an objective bystander, look at you and go like, what is going on? Because you create trust problems. Now, the trust problem they've created with the partner must be fixed. Why? Because that's how you are creating value.
Is it only they are doing?
No, let me end
if
on
there's a fight between 2 people, why are you believing that?
What I'm trying to say is that the jurisdiction is important.
Would it not be that
we want to control our
assets?
Unreasonable? I'm coming. We want to control our assets.
Yeah.
Even the simplest technology in gold mining, ball bearings, we don't make enough of it.
Yeah.
When it comes to drills, when it comes to all the key technologies that you need for mining, we bring them from overseas. Over time, we are building that capacity. That's exactly what happened to Asian Tigers. They didn't start off by strong arming international investors. China allowed Apple to come in and for many years work with Foxconn, and Foxconn never gave Apple the slightest excuse to be worried.
So are you suggesting
I'm coming. Over time, they acquired all that technology, and now we have Huawei, we have all these big Chinese technology that are producing the technology. So the way you do it and build a national champion is through strategic sophistication.
Right.
If you do it buga, you lose out. That's the point I'm making. You lose out.
Are you being fair if it is? Because if people are disputing, and you want something, and we are at court, maybe the other party is also doing buga.
That is why, as someone that is interested, I've read everything. Every single thing. And I'm telling you that from what I can see,
you don't think that
from what I can see, the actions that the Ghanaian company has taken has made the meeting of minds harder. And without the meeting of minds,
what about the actions of the other party?
I think that
have their actions been kosher?
I think in this not kosher because they are human beings.
They are also
and they're a commercial entity, so they will try to maximize their interest. But I think that on the balance, from all the documents I've read, on the balance,
but they are both commercial entities, aren't they?
True, both commercial.
So both of them are trying to maximize.
Very good.
So why should one's attempt to?
But when I look at what the actions each party has taken, I think the Ghanaian party is more in the wrong.
But is it also
And my
a question
prediction,
of, right,
my prediction is that if the matter goes all the way through arbitration, the Ghanaian entity is likely to. But I'm coming back. Just as we said with Springfield and the Ghana matter and all those.
We can come to the. I'm saying that from the Trump context, there's a view that, look, for example, the Trump meeting with the Liberian companies, they are saying basically we're going to build rails to the port and we're going to export the raw material. And there's a feeling that Western capital is still thinking about Africa in a very pre-colonial way.
Yeah, we should create a strategy which allows us. Let me make the point. It's very important.
I'm saying that. Forgive me. You are very knowledgeable. Do you not think that whilst you point out what the Ghanaian company is doing wrong and they can do to improve, there should also be some strong policy prescriptions around how countries should also strengthen their local private sector to be competitive, to be able to own some of these assets. Okay.
So
to make that equally forcefully.
It's local content and capital.
Local ownership, local capital.
Yeah, but the local content is built into the local ownership. Yeah. If you own the asset, but all the money is from overseas, and all the technology from overseas, you don't really own it. Yeah. Which is what we tried in the 70s and we failed. Yeah. Remember that, not even late 60s, all the way to the 70s, we had, Professor Nana SKB Asante and others come up with a powerful strategy to own the majority of all our mines. Yeah. We failed because we didn't pay attention to capital and technology. Correct. So the way we go forward in owning our assets and control our mining assets is that the capital and technology bit, which we require from overseas, we should be smart. Just like the Asian tigers. Let them bring in the technology, use all manner of skills for them to handle. Our local content policy should be so smart that by the time you are through in 10 years, all your subcontractors have enough capacity and technology to do that. Which one is closest to that plan? We have about 5 or so companies. E&P is probably at the very top, right? I'm worried because E&P is not taking steps. That gives me confidence that by the time we see, a blink of an eye, they will have carefully and strategically manipulated the introduction of the right technology and capital so they can move forward and do it. Why? Because this action they are taking, I don't think they're right.
But some of the capital is coming from West Africa, which is
true.
EBID.
But it's not.
So it's a great idea, right?
Yeah.
A Ghanaian company.
Yeah, but look at EBID's own fundraising.
Yeah, but I'm saying that
and EBID's own credit rating. And ask
I think
yourself,
they have B plus stable.
No, B.
B stable.
B stable. So ask yourself, who does those ratings? And who do those people listen to? Do you think that if EBID does things that the average bystander, a reasonable person who's a credit rating,
but maybe
looks at it and go like, oh, this is too.
But some of the things we have said could also hurt them.
And then downgrade them. Do you think that EBID will be in the position to raise money at the right time? But
what I'm trying to say is that capital is very cultural too. So, you see, let's not assume that everything that happens globally is objective.
True.
Just let me ask the question. There are interests that do not want Africans to raise money to own anything.
True.
And as a strong think tank with all the information you have, you also need to balance your advice to how the locals should behave. The foreign guys should also stop seeing Africa as some place they can easily exploit.
I agree.
Which is why, if you look at some of the actions, at least I haven't seen the response of Azumah. It seems to me as if they're also trying to play smart. Which is why, from a nationalistic point of view, we can say, these guys think we are foolish.
No, but
that's the way you can see it.
No, but before you sign an agreement, be very thorough about what the business idea is and the rest of it. So that kind of problems where it appears as if you have a different agenda, should not lead to a point where we already start to commit and then we make public announcements. It creates reputational issues.
Correct.
So my argument is that if you're a national champion for Ghana, E&P is a national champion for Ghana, we must hold you to high standards. And in holding you to high standards, it is really, really dangerous for you to start excusing everything you do by on the basis that you're a national champion. Rather, we should say, no, E&P, this one day you should not have done it this way. If you have issues with them, don't go and do a public event and launch it. Right? Even if you want to do something with EBID, you should have your own arrangement with EBID, maybe a memorandum of understanding that we have a strategic relationship. If I bring this asset, you fund it. And then do it quietly and do it. But if you stage a big event, pop champagne, put people in the uniform of the company you are in dispute with, bring them there. And then when you finish and people complain that, because the company issued strong statements, they dissociate themselves from it. And then when we talk about it, you then have your business development director write a statement in which they call me stooge, they insult me, they insult everybody, describe us as enemies of the country. What kind of national champion is that? That's not sophisticated. So you have to be strategic, you have to be sophisticated, then we can back you. We want Foxconns, we want Huawei, people that, look at the battles that Huawei is fighting in America right now and the rest of it. You have to see the way they are playing it. You see the strategy and the rest. So we want national champions that understand that international business have reputational consequences. Yeah. You don't do things that basically make Ghanaians look like we are not serious people. But do that. But let's not. The Ghanaians also go outside and look at the agreements that Zoomlion is signing all over Africa.
Yeah.
Do you want Kenyans to behave to Zoom that you're also a foreigner? So when you sign this agreement, we don't care. We'll throw you out. Is that what we want?
No, we want balance.
Very good.
So we also want our foreign partners to also respect us.
True.
And then we also need the best minds to call for a level playing field.
Okay.
All right? Look at what Dangote went through in putting up the refinery.
So why is it that when I ask E&P for information that in their minds suggests clear evidence that this agreement has been broken or something has been wrong, we don't get anything?
But we cannot use your experience with the company to then adjudicate on the companies of ours.
No, because I'm a commentator on it.
Yeah, but that doesn't matter.
So
maybe they didn't. I don't know. That shouldn't be the basis for.
No, so my suspicion then is that they don't have any evidence that the other company has behaved.
But companies can decide not to talk depending on which stage of the transaction they are in.
But I've evaluated it independently.
Yeah.
Looked at so many factors, and I've concluded that on this matter, E&P did more wrong. Because I'm not clear what the other company was supposed to do. They say raise money on our books. You agree?
They said the company frustrated every attempt to do the EPC. They stated
the
that clearly.
EPC contract was, first of all, you do the DRA first. Pay the money for DRA.
They say anytime they try to even get the DRA going, these guys were just stalling.
No, but the point is that they were stalling how? What was the mechanism? The issue is that they were not paying DRA. Is what the company is saying. Is that for DRA to move forward, you need to pay them, and we have agreed to split the cost. You pay half, we pay half. You are not paying, and you are trying to whatever. So they decide to go ahead and pay DRA to finish it. So how is that their problem? My point is, if E&P really, my view, I have been in this country for 20 years doing this objective analysis across different companies. I've tackled foreign companies like Atlantic Lithium. I've tackled foreign companies like ECA. I've tackled Talo. I've tackled so many foreign companies. If E&P genuinely had evidence that this other company is the one in the wrong and this is a Ghanaian company being beat upon, they will have made that evidence available, even if not to me, to the public. What is the evidence that they have made available so far? I've seen documents. I've seen bank statements. Yeah. All I've seen are claims from E&P. The documents must be shown. What are the documents?
They sent
this DRA document. Did they send you the DRA global document that shows that
Northern Reports published a story today showing some email from the company agreeing to extend the dates for the financial, what do you call it?
But that was not the only item.
No, I'm just saying that. So they put things out through the mediums they want to.
Okay, but those information that is out there that I've seen does not show substantial wrongdoing on the part of the foreign company. If it did, we'll call them out.
Do we know when the arbitration will be determined?
No, because it's barely started, right? So, and these things can easily take a year or a year and a half. But the important thing is that we have to realize that if we want to own our national assets, it's about capital and technology. We've tried it before, where we've not sorted out the issue of capital and technology. All those mines failed. The State Gold Mining Company nearly went bankrupt, and we went back and brought foreigners in. So if we want to do it another way, we should be sophisticated, we should be strategic, we should do these things in a manner that will lead to the outcomes we want, which is that we control more of our assets. You cannot do it this part by antagonizing for international capital, etc. It doesn't work for anybody. Secondly, if we say these are our laws, you damage those laws to benefit one or two companies. It damages the environment as a whole. Before long, you will see Ghanaian companies that don't have the certain political heft. You see them very clearly also now in competition with E&P. I have seen lawsuits between Ghanaian companies and E&P. I mean, since they sued me, the amount of information that I've called it, being brought to me, etc., is unbelievable. And I've seen information that suggests that local companies are also suing E&P. So in those instances, who do we favor? Because they are all Ghanaian companies. So strengthen your governance system, make your laws very clear, policies that you want to benefit local companies and create local champions, make them solid. Do local content policies that are thoughtful. We shouldn't be importing ball bearings. These are simple metal balls that we use to crash ore. We import them. We shouldn't be doing that. We should stop this thing when we say because of caterers and whatever have done well. Mineral Commission have done well because a lot of caterers are now serving mines. No, it's technology. What kind of think of the chemicals that are used in all of this? We should produce them in Ghana. That kind of thinking is policy driven. It's not driven by making favors, issuing favors to one or two companies and making them benefit.
Right, there's a lot that can be said about Ghanaian companies, African companies, and a level playing field and all of that.
I agree.
And I don't think we have enough time to go into it. But I just keep pointing out that.
And I keep telling you that I'm the biggest supporter of Ghanaian national champions.
Good.
I'm the biggest supporter of Ghanaian national champions.
And I've read you.
There are mining services companies in this country who nobody knows of, who are doing amazing things. where one of the people in our own Aliwa group and the rest of them, managed to get a helicopter service running, etc., with incredible financial ingenuity. If you create an environment where people who just have power ride roughshod over foreigners, they will start riding roughshod over locals as well. Then the people that have real entrepreneurial capacity and can do amazing things can't do it because they don't have the power. So it shouldn't be that because you have access to power, you do what you want. You see, it shouldn't be that.
I keep making the point that from where I sit, when two people are fighting, until the matter is determined as to who is wrong, we cannot assume that one is wrong.
But one cannot stage a big event that suggests that there's no problem.
Okay.
Because there's a problem.
Maybe that's their
when you stage a big problem that says, I've acquired the mine,
maybe that's their
and then there's champagne. Do you see the champagne that was being popped?
But that's their strategy.
What kind of strategy is that? I pop champagne, I bought the mine. Which kind of, and then you have a big international bank, you drag this CEO
But you cannot be more interested in their success than they are.
Oh no, they want
so they obviously know what they are doing.
But okay, now are we discussing the amazing Black Voter Gold project, or we are discussing some murky document? Look at how many documents have you read?
The chieftain of
nobody can doubt the prominence and
Samjona was there.
Samjona.
It was there.
And what did he say? He said we should support Ghana's gold industry. And I didn't hear him say that we should go and strong arm.
And he said we shouldn't
politicize. Beautiful. And I haven't politicized it. Even though people forget, but Mr. Ibrahim Mahama is a politician in his own right.
By the way,
people talk about he's a brother of the president. It's more than that. He's his own big player in politics.
Does it matter that this thing happened before his brother won the election?
No. Because people think everything's about the president. No. Mr. Ibrahim Mahama himself is a major player in Ghana's politics. Okay. I have interviewed people who tell me that when it comes to the political landscape, he's formidable. Okay. In terms of supporting, financing, all manner of things. Okay. So he himself is a politically exposed individual in his own accord.
You haven't linked it to his brother's presidency?
Not necessarily.
You haven't done that.
The only challenge I've had is that there are political undertones because they are the two people that was nominated by him are appointees, either previous or current appointees of the president. So they work in government. One of them has an affiliation with Senate. The other has an affiliation, actually runs the Ghana Infrastructure Investment Fund. So you have people who are government officials, and they are sitting on the private board involved in this murky conflict. It suggests that there's a problem.
Let's explain that. So sorry, let me get straight. GIF is the infrastructure fund for the country.
Yes.
Do we know government's policy around ownership of mines and whether they think GIF has a role to play?
I think that there's a connection there because GIF can provide infrastructure to mining areas. So my concern is not that he's supposed to be doing pineapples, but somehow he's found himself in mining. My concern is that because he's a government official, he runs one of the national sovereign funds. If he's involved in a heated battle like this, for a lot of objective bystanders, that suggests potential political.
Which of the two came first? Was he on the board before he became GIF, or GIF before board?
No, one of them had been appointed in the first administration of the current president. And then subsequently, now I'm told that he's being considered for another appointment in the government again. The other one was made the head of the whatever before the launch. So my argument is they are government officials, right? So if they are involved in a conflict and they are directors and they are part of the camp of E&P, and then an objective bystander looking at it, then how can the private company get level playing field? You have even government officials working for E&P, sitting on their board, and because the E&P brought them there, there might be a perception that they can exercise some governmental influence. So all of that creates political undertones around it.
Do you understand it when some of your readers on social media say they are not happy with you because you are... People want you to take a position for Ghana against a foreign company.
Yes.
But you think you want to be objective.
No, I think that E&P is not Ghana. Oh. E&P is something that can help Ghana. Okay. If we position E&P well.
Okay.
If we don't position E&P well, E&P can actually hurt Ghana. You understand? So the only reason I'll be interested in E&P's success is because you build a supply chain in which several companies that supply E&P will do well. If we damage the governance environment, E&P will abuse them. Okay. Too. If we say, let's relax the rules and let them do
let's strengthen the governance environment so that when they succeed, their success is sustainable.
It's sustainable across not just them, but the entire supply chain of other small companies benefiting from mining. On top of that, for E&P to truly succeed, E&P needs to sort out its international reputation for sure. Okay. Why? Because not everything it needs can be acquired locally. Secondly, To the extent that we export our gold overseas, we are doing gold bond, most of which is anchored on the basis that we need to have our gold trusted, we have responsible sourcing. There's so many things that we do that still we are still part of the international system. And I hear a lot of people say that forget about that stuff and it's all rigged and everything else. But when it's rigged, and when it's imbalanced, and when it's poor, etc., that is even when you need the smartest strategists.
Is the gold board a smart strategy?
I don't like the way it was, the way they went about in creating it. I think that.
What about the idea of it?
I think that a company to strengthen the supply chain is needed. And because no private company will get into it, a government entity that do supply chain management is needed. I don't think the police powers they have been given is necessary because we already have a big police force. They can't, if 50,000 police people can't do it, a few task force people or whatever will make a difference. I don't think the regulatory funding they have been given is compatible with their commercial strategy. I don't think the fact that they also have a financing agenda helps with them sorting out the issue about responsible sourcing. You see, when your goal is to maximize how much forex we make, and at the same time, your goal is to prevent galamsey and fraudulent gold from coming to the supply chain. At some point, some of your officers will get confused.
But I'm
coming because one of your officers is busy trying to boost the gold. Another of your officers is going like, oh no, this gold, did you look double? Are you sure this person, he's not galamsey? At some point, you get conflicts in the company. And it creates cultural dissonance.
So it's possible that there could be tension in the objectives.
So if I had anything at all to do with gold board, and I'll be honest, when they were setting up gold board, they said the law, some of the draft provisions of the law to a lot of people in this country. So it's one of the best consultations I have seen. The problem is that the information that we need about every other aspect of the strategy in the policy was not there. So for me, just looking at some random provisions was not enough. And it's when finally I saw the final draft bill that I went, wow, what is this? We've created, if you had a policy octopus made with a commercial squid, that's what you get a gold board. It has so many mandates.
Very interesting imagination.
It has so many mandates that I looked at the board and I said, what are we creating? We've never created an institution of this caliber in our history. It has more powers than the Pope.
But can we look at the jump in the value of gold exports and the volume as initial success of the gold board to point that maybe they are doing something right?
No, because the existing policies that were initiated just a couple of years ago to drive output, the government buying some of it from the small scale, buying some of it from the large scale, etc. All of those policies have not changed. So
you don't think the gold core necessarily work that's increasing the volume of? No,
because the policies they are working with were there before they came in.
They were claiming that some people were exporting gold but were not getting the proceeds because they were smuggling it.
Yes, but
so they've kept smuggling.
But their law was not ready until about April of this year, right? So their policy instruments were not ready until about policy.
So you cannot claim anything from January to March.
On top of that, from the time that the law was passed, they have not fully set up. They are still doing hiring. The new licensing regime, which is supposedly superior to the existing licensing regime, only concluded because they only issued licenses.
But I know you can, based on announcement.
They only invalidated licenses and issued.
But I know that sometimes when you announce an intention, it may change behavior.
True, but that is why I say that some of the some of the boost in exports, apart from the price effect, when the price goes up, uneconomical reserves become economical, so people produce more. Apart from that boost, some people who are also stockpiling or whatever, were also exporting ahead of the new regime. So my view is that some of the boost that we saw, the boost in volumes that we saw, were driven by extraneous factors, not due to policy.
Because they also claim because the price they offer, people feel comfortable selling their gold to them. Because they are offering a market price. They are not behaving like Cocoa Board where they offer, they just determine the price. But
are you saying that the BOG...
No, because they are linking that to, they are linking that to, we are talking about small scale gold now. They are linking,
yes, but
they are linking that to reduction.
Program was already in place.
So and you don't think it was gold board setup that increased?
Red Sapphire, which is one of the companies that the Bank of Ghana uses to export. Are you aware that was the same company that they were using before this change happened? And that there were all manner of controversies about beneficial ownership, that the people that were beneficial owners were not the same as the real owners. There was some Pakistani, and then eventually they had to change the corporate governance documents. There's a lot that was going on. But my point is that much hadn't changed. So it's now that the new license regime is kicking in, now that they are invalidating the previous arrangements, that we can start to measure their effects.
When will we know if gold board is working?
From August to the end of the year, we should be very observant because by that time they will have dismantled the legacy system. And once they've dismantled the legacy system, then their model will now be tested. And their model will include nobody else can export through me, some of the licenses have been invalidated, and some of them have not come back and completed the licenses because they think the amount of money they are being charged is too much. So they are back, and will these people go into smuggling? All these matters will be tested, and we just have to have an eagle eye to do monitoring and evaluation effectively to see if it's sound. And to close up on E&P and Azumah, my point is that if we want a national champion, we should hold them to high standards. We should make sure they succeed spectacularly. The international system is unfair. There's racism. There's all of these things. But the biggest successes in the Asian tiger story, many of them manipulated that system to achieve their successes. So we need national champions that understand it and play the games right. If you do things that give some international journalists the opportunity to write, bad things about Ghana and the rest, it doesn't only affect people that are investors coming in. It affects customers of Ghanaian companies. It affects Ghanaians that go outside to do business to get technology transfer. It affects all of us in different, diverse ways. And so we should not encourage it. E&P should definitely do the right thing.
We'll wait to see how the cookie crumbles. My team has been screaming that my time is up. I couldn't hear. I couldn't hear. So if you are going to give me a memo, you have to add him to the memo. Thank you for watching the show. I think it's been good talking. Hopefully, things will get clearer as the days proceed. My name is Bernard Avle. My guest was Bright Simmons, and we're discussing the E&P Azumah saga with a little sprinkle of gold board at the end. Have a great night. We'll see you next time. Bye-bye.